we'll start with the general statement, which is available on the screen. I invite your attention to the screen as well. So the general statement with which we can start our discussion on infringement of patent could be like this. Patents grant their owners the right to exclude others. It's a right in rem from practicing the claimed invention. So patent is a claim for an invention, and an exclusive right is granted to the patentee. And as it is an exclusive right to do the whatever things like make, use, manufacture, sell, import, export, etc., with regard to that particular invention. Any person who is doing anything which is covered by the exclusive right or rights of the patent holder is infringing a patent. It's a violation of the patent. So, in general sense, infringement of a patent would mean unauthorized practice, unauthorized, doing anything which is covered by exclusive right. So, if the defendant is doing manufacturing the product which is the outcome of an invention, that is an instance of direct infringement. So the rights covered by patent is an action which is exclusively given as right to the patent holder, is done by, is exercised by any other person. That person is doing direct infringement. That is a plain case. It may not require much explanation. Of course, we might have to have some discussion, but it is comparatively easier for us to understand. There is yet another category of violation of patent, which is known as indirect infringement. The question that arises is, what is indirect infringement? I've got some indicative words and sentences on the screen itself. Indirect infringement would mean a defendant is inducing the actual infringer, the direct infringer, to infringe. So indirect infringement does not involve direct use of the rights, direct misuse of rights granted to a patentee. Here the person it's something like abetment. The person is inducing the infringement of a patent. And the person is also helping or contributing towards infringement. So there is no direct infringement. At the same time, the action of the indirect infringer is contributing towards that or is inducing another person to infringe patent. So that's a basic understanding of patent infringement. That's not all. We have to go further. Whether a patent right has been violated. So in order to decide whether a patent has been infringed or not, the question can be restated, or it could be understood like this: whether the patent right has been violated or not. That's the question. Then obviously the question is, what is a patent right? Only when you are clear about what is a patent right, there's a possibility of asking the question whether patent right has been infringed or not. So that requires two steps. That involves two steps. The first one is, what is the scope of patent? So plaintiff has a patent, and there is an allegation by the plaintiff that the defendant has violated the patent. So the first and foremost question the court should address is, what's the scope of patent? That's first and foremost important. And next one is whether the defendant exploited patent and plaintiff's patent. So having clarity about the first question, what is the scope of patent of the plaintiff, then we will have to understand what exactly is defendant doing. Then the court will go for a comparison or an exercise wherein the court will try to understand whether the plaintiff's patent has been infringed or exploited by the defendant. These are the two steps, two processes involved in a major question of patent infringement. Am I making sense? I think the explanation is good enough for you to understand the ideas. Now, moving further. So the first step is ascertaining the scope of plaintiff's patent. Scope of patent is the scope of claims. That is a major understanding you should carry home. I think you already have that. So patent is granted in respect of an invention. You'll have to make an application for that, and you'll have to give a techno-legal document called specification, complete specification, along with the application, and it will have very many parts like title to description to background and very many things which we discussed. And the most important part comes at the end, and that is claims. That is a part relating to claims. So it is by reading the claims and many times interpreting the claims, properly understanding the scope of claims, we understand the, the scope of a patent. In other words, in simple words, the scope of a patent is the scope of the claim. The statement could be, made simply like that. And then it involves the interpretation of claims because it's a technical document, it's a techno-legal document. The words used are technical, and of course, it's covered in legal color. And a proper understanding of the scope of patent involves interpretation of the claims in the specification. Now, in order to do that, there are certain observations made by the guiding observations made by the courts. One of the most important cases on the point is Catholic Components Limited versus Hill and Smith Limited, which is an English case. It's not an Indian case as such, but as we heavily follow on English legal system, these cases are also followed in India. And Catholic Components Limited versus Hill and Smith Limited is one of the major cases, and we just have an observation made by the court, which is very important as far as interpretation of interpretation of claims are concerned. It's an observation made by Lord Diplock, and it goes like this. Or rather, it established the principle that patents are or were to be read in a purposive manner. The principle of interpretation should be purposive interpretation. But we require further explanation as to what purposive interpretation could be, which we'll understand through the course of our discussion. Now, we have a case here. It's an English case, a case of 1990s, but still relevant to some extent, and it has been overruled to some extent. But still, this case would be worth a while. The discussion of this case would be worth a while. So the case, the title of the case is like this: Improver Corporation versus Remington Consumer Products Limited. And let's understand what it is. Let us go to the facts. The facts are like this: the patent, the invention with regard to which the patent has been granted. The patent covered an epilatory device having a curved helical spring driven by a motor. Do you understand anything from this sentence? Anyone, Mr. Abjit, do you understand anything from this? What do you get to understand, Roland? The patent covered an epilatory device having a curved helical spring driven by a motor. Does that make any sense to anybody in the participants? I think Abjit is not available. So, does it make sense to you?
Meaning correct.
Yeah, it's a difficult thing because we are dealing with what we call as patents and new technology. Technology never existed, and novel technology which involves inventive step and things like that. The spring, when rotated, gripped hair between its coils and plucked them from the skin. Does that give any indication to you, Mr. Abjit, now? Does it give any indication? It is nothing but a hair remover. It is nothing but a hair remover. For the better understanding of the case, I went to the site of the company, and I've got the picture of the very product which was an issue in the case. It is nothing but a hair remover. It is not as epilady, and it has got some speed reduction over there, and it's like this. And what happens is you have something like a spring at the top end of the picture, and you have a battery inside, or you have a charged battery inside, and you have a button. I invite your attention to the screens. You have a button which is red in color. So when it is pushed to the front, the machine starts working. And if you keep it near to your skin, especially it's for ladies, I think men may not do that. So the spring rotates, and in the rotation, the spring will contrast, and it will contrast and it will amplify. In the sense, it does like this. So there's a gap in between the spring, various coils of the spring, and when it is contrasting, the hair will be gripped in that, and it will be. For a better understanding, let's look at from the front portion. This is how it is, and this is this part which is being being come in touch with the skin. So it rotates, and also it does like this. So the skin gets entangled in between these gaps, and it can be removed. Of course, it's a painful affair, but it gives a glamour. It's supposed to be. Let's move on with this. Now, what happens is, this is the patent. This is the patented invention. There is an allegation by the patentee, the inventor holder, that the alleged infringement, what it does is, that is the product of the defendant. It is alleged by the plaintiff that the alleged infringement, the alleged infringing product, replaced the spring. Replaced the spring. The spring here you get to see on the screen. They have replaced it with what? They replaced it with a rubber rod. They replaced it with a rubber rod having slits. It is cut like this, and rubber rod has got spaces in between. Slits in its surface. So instead of the spring which you get to see on the screen, the infringer, the alleged infringer, replaced a rubber rod, and rubber rod is cut like this. A lot of slits are there, and it works the same way the plaintiff's machine worked. So it also has got some slits in between. It also has got the spaces in between, but there is a difference, and that difference is that instead of the spring, which you get to see here, which is made of made of metal and also plastic, which is hard, hard in substance, that is replaced by a rubber rod, which is cut like this, which has got slits in between, and it works the same way. It rotates, and it also has a contrasting and all those qualities, and it works in the same way. Now the question here is, it is not the very same equipment that is used by the defendant. Is that clear? It is not the very same equipment that is being used by the defendant. Defendant has made certain changes in that, but the changed device, the defendant device, works in a way which the plaintiff device worked. The same way it works, but the substance that is used here is different. So if you ask the question, is it the same? No, because the materials used are different. But if you ask the question, is the invention works the way the plaintiff's invention worked? If the defendant's device works or makes use of the same, same method which is used by the plaintiff, The answer is yes. Then the question, there is a complicated question. There are improvements, the materials are different, but the way in which invention works, the defendant device works, is the same way that plaintiff's device works. Am I making the point clear, Mr. Abjit?
Yes, sir.
Okay. Now the question arises is, in this situation, whether there is an infringement. So that question, in the context of this case and in the light of the fact situation which we are aware of, could be restated like this. Whether slitted rubber rod was a helical spring. The spring is known as helical spring. That's a technical terminology they use, or phrase they use. And whether slitted rubber rod was a helical spring, are they one and the same? The answer could be yes. And in the context of these devices, the answer could be no also. So here, in order to decide whether there is an infringement or not, there are certain complications involved. The the method of comparison may not work, because there are differences in the substance used. Now, how are you going to decide this? Many of the patent infringement cases are like this. Definitely, the defendant will not be using the very same identical device or identical invention in respect of his invention. So he will definitely go for some sort of changes so that he can just say that there are changes. So this is one such situation which really, challenges a court with this kind of complication. Let's see what happens here. Let us understand. The kind of questions the court asked are the following. The first question, whether the substitution of a rubber rod had material effect on the way invention worked. I want all of you to understand the question first. Whether the substitution of a rubber rod had material effect on the way invention worked. Whether the substitution had a material effect, substantial effect on the way in which invention worked. Another way, in the other words, does the variant here is the rubber rod, have a material effect upon the way in which the invention worked? That's the same question in a different form. And if the answer is yes, if there is substantial difference in the way in which defendant's invention worked, then if the answer is yes, the variant is outside the claim or patent, then it's a different variant, different substance, and it makes the product of the defendant different. So it is outside the claim of patents, plaintiff's patent. So it is not an infringement. If it is no, meaning to say, if the way in which invention works has not substantially changed, even though the substance used is different, then it might amount to patent infringement, because there is no substantial change in which the device works. Is the position clear? Are the questions clear? Is the explanation sufficient and adequate? I expect a response at least in the chat box. Yes.
Okay, sir.
Yeah. Thank you. So moving further with this, we have another question, second question. Whether it would have been obvious, it's important, whether it would have been obvious to an expert, because the patent and patent infringement will have to be decided not from the point of view of an ordinary advocate or an ordinary person. It should be understood and decided from the point of view of an expert in the area, a person skilled in the art. We spoke about that earlier. So this question, the same question, should be asked from the point of view of an expert. So the question can be asked in this fashion: whether it would have been obvious to an expert that the rubber rod would work in the same way. That is, whether it is had it been foreseeable, for an expert that instead of the plastic and plastic and metal spring, if rubber rod is used, it would have worked the same way. Or in another formulation of this, would this variant have been obvious at the date of publication of the patent to a reader skilled in the art? Would this variant, what is the variant? The rubber rod instead of the other spring, have been obvious? Would that have been foreseeable at the date of publication of the patent? That date is also important. It is not on this date today when we are deciding the matter. We need to consider this, whether it would have been obvious to a person reading this on the date. It should date back on the date on which patent was published, on the date of publication of patent application, to a reader skilled in the art. It is not no, the obviousness. I'm sorry. It should be obvious to a reader, not like you and me. I suppose if we are not experts in the area, it should be obvious to. If it is obvious to a person in the art, in that particular area of expertise, then it is within the patent, within the invention of the plaintiff. Then it will amount to infringement by the defendant. If it is otherwise, if it would not have been obvious to a person skilled in the art, then it is not obvious. It's outside the scope of the patent of the plaintiff. And then what happens? There is no infringement. So if no, the variant is outside the claim, then it is an independent invention. There is no infringement. But if it is yes, it would have been obvious to a person skilled in the art, then it is within the scope of the plaintiff's patent, and then there is an infringement. I think I made the second question also clear. Moving forward to the third question, whether an expert would have understood from the patent that the patentee meant to confine. This is a similar question, but in a different light, different dimension. We'll read it once again. Whether an expert would have understood from the patent, from the specification and the claim, that the patentee, the person for whom now they have a patent, the plaintiff here, the plaintiff meant to confine his or her claim to a helical spring. From the words, when an expert reads those words at the date of patent publication, whether he intended, what is obvious to the person, what is understood by the expert on that date, whether his claim is confined to helical spring only in its primary meaning, not in a wider generic sense. Here we will have to go by the words used in the specification and specifically the words used in the claim. So whether what was the intention of the plaintiff? Was the intention of the plaintiff to confine his invention to the helical spring alone, not to rubber rod? That's how we need to understand that. And the same question in a different way, would persons skilled in the art have understood from the language of the claim? I'll read it once again. We need to apply our mind to understand this. Would the person skilled in the art have understood, an expert in the field would have understood from the language, not his own foresight and things like that, from the language of the claim, that the patentee, here the plaintiff, intended only the primary meaning of the claim, or whether the plaintiff intended it in a generic sense. If it's used in a generic sense, it includes not only a spring, but also a rubber rod. So for that, to interpret that and for a proper understanding of that, we'll have to go to the language of the claim and language of the specification. Are the questions clear? Are the questions clear?
Yes, sir.
Yeah. Now the court answered. What did the court say? Court said, the change to a rubber road had no material effect on the way the invention worked. The first one. The change to a rubber road. Instead of a spring, you have a rubber road here. No, that is introduced by the defendant. And the court found on facts and, of course, on interpretation also, that the change to a rubber road had no material effect on the way in which invention worked. Invention worked the very same way the plaintiff's machine worked. And second observation, second finding is this: it would have been obvious. It would have been obvious to an expert, a person skilled in the art, that a rubber road would work in the same way. It is foreseeable, in other words, it's foreseeable for a person skilled in the art on the date of no publication of the patent, on that date, that a rubber road would have worked the same way the spring worked. So these are the two findings. Let's go to the third finding. But that but is very important there. I want all of you to understand this. And but the expert would have understood from the patent that patentee meant to confine his claim to a helical spring in its primary meaning and not in a wider generic sense. Though it would have been foreseeable to a person of skill in the art, the finding of the court is this: the expert would have understood the kind of language that is used in the claim and also in the specification indicates a literal, limited scope of patent. So it goes like this: the expert would have understood, though it would have been foreseeable for an expert to use a rubber road instead of a helical spring. The way in which language is used, the way in which the claim is made, the language used in the claim is such that the court has understood, the court has observed that the expert would have understood from the patent, from the claim, that the patentee meant to confine his claim to helical spring only to a helical spring. That is, only the way in which the plaintiff's machine worked. It is not wide enough. The language used is not wide enough to include anything other than helical spring. It is used in it is not used in a generic sense, meaning to say that the right of the plaintiff is confined to the machine with a helical spring only. And for that reason, the rubber road did not infringe. Meaning to say that though it would have been understood by the expert in the field, the wording or the language used in the specification and the claim indicate, the language and the words used in the claim indicates that he or the patent holder or the applicant at that time, here the plaintiff, intended to confine the machine with a helical spring only. So use of rubber rod is not covered by the plaintiff's patent, and when a different material is used, it comes outside the scope of patent of the plaintiff, so it is not an infringement. It is not an infringement. Are things clear? Are things clear?
Yes, sir.
Yeah. But there is an important but again there. You have another case, again an English case, the name of which is available on the screen. I would request some of you to read it, or you can read it yourself. It's a bit difficult to read, so I just leave it the participants to read it. I invite your attention to that. It's a House of Lords decision, and this is the case which we discussed. Improver Corporation case is the 1990s case. It is reported in the year 1991 in Fleet Street Reporter (FSR). But the case on the screen is a House of Lords decision in the year 2004. And to some extent, at least there is an improvement, or to some extent, it has improved the decision, improved the position laid down by the court, English court, in Improver Corporation decision. So I think it is important for us to have a look at that as well. We may not go to the facts of the case, but we'll look at the observations made by the court, which is in deviation, which is different from the observation made by the court in the corporation case. It is common. It's a common misunderstanding. The court observed. The House of Lords observed. It's a common misunderstanding that words of the claims, because that is the most important thing in a decision as to the scope of patent and also the question of infringement of a patent. So it's said like this. It's a common misunderstanding that the words of the claim should be understood as what the author, what the claimant, what the plaintiff here. Author would mean the person who has come out with the patent claim. The author used them to mean. This is not the case. That's a common misunderstanding. Because in the improver case, what the court has said is the language used is the intention of the person. Intention of the person who has made the application as understood through the language should be considered. But in this particular case, House of Lords said the position is not right. That is not the proper test to be employed, proper test to be used. Instead, the court said, House of Lords observed, importantly, the second paragraph is important for us to understand. This shows the present position of law. We will have to get into the niceties of it and also the subtle difference. The difference that would appear to be subtle difference, but it's actually a major difference. The claim should be understood as what a skilled person would have understood the author to be using the words to mean. It is not what the author would have intended, but it should be what a person reading it, a person skilled in the art, reading it on the date of filing of application would have understood. So there is a change in the way in which test is to be understood. The improver corporation case, what the court has said is the word should be considered from the point of view of the person who is claiming it, the plaintiff here. But now there's a shift, and that's a major shift, though the difference appears to be minor and subtle. It's a substantial difference. The court said it should be considered from the point of view of an expert in the area of art, in the area of the technology. So let us read the test once again. The claim should be understood, the claim should be interpreted as what a skilled person at the date of filing of application would have understood. What he meant is not the question. The question in improver corporation is what the person meant. What was his aim, what he had in his mind. But here what it says is, that is not the question. What a person skilled in the art would have understood. Would have understood the author to be using the words to mean. So what a person skilled in the art would have understood to mean by the author on the date of publication of the patent. So there is a shift in the test by the House of Lords in the case. This is the 2004 case. And this case is still understood to be the law laying down case, and it is still respected and followed even in India. Are the things clear? Are things clear?
Yes, sir.
Yes, sir.
I think, yeah. I think if this is a position, I think we have just completed half an hour assigned for us for the day, and we have some more things to go before we complete our discussion on infringement itself. There are certain rules as to interpretation of claims. I think it requires some time for us to some substantial time for us to understand these rules, and it's important for us to understand the rules also. So I think we can understand the further things relating to infringement of patent in the next possible day of discussion. That's it for the day. If you have any, clarification to make or any dissent to make or any opinion to make, I'm open for that. And if it is otherwise, we will
different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is, I think, is a constitutional